Hi, everybody. Welcome to Trial Alchemy. Today, I'm delighted to have as my guest William Shapiro, goes by Bill. And Bill is the owner of his own office, law offices of William D. Shapiro. Bill's been practicing law in California since 1979. You beat me by a year, Bill, so you're a veteran here. And he's been very successful as a trial lawyer for plaintiffs. He's also been very involved in a lot of organizations. I won't go through the entire CV, but to give you some highlights, Bill's a member of the American College of Trial Lawyers. He's a fellow. He is a fellow in the International Academy of Trial Lawyers and the International Society of Barristers. He's also, of course, a member of the American Board of Trial Advocates, ABOTA. He's a diplomat. Now, Bill has been involved in ABOTA. He was the president of this chapter in San Bernardino and Riverside, but recently he was elected to be a vice president, which he will start next year. And that means in 2026, Bill's going to be the national president of ABOTA and lead the organization for that year. Now, Bill's also been involved in other leadership roles as the president of the Consumer Attorneys of Inland Empire. He's also been the president of the San Bernardino County Bar Association back in 2008. And he's been recognized for his excellent trial results in a lot of ways. I'm not going to mention all of them. He's been listed as in America's top 100 attorneys, best lawyers of America for many years. He's been a winner of the top verdicts for 2022 from the LA Daily Journal. He's won all kinds of Trial Lawyer of the Year awards. One that I think is a neat one is he was a Trial Lawyer of the Year for ABOTA, which is all the ABOTA chapters in California in 2015. And he was celebrated in Hawaii at the annual convention. So uh, Bill brings a ton of experience today, and I appreciate so much, Bill, you coming onto the show and being a guest. So thank you for joining me on Trial Alchemy.
Well, thank you, Monty. It's always it's a pleasure to do your podcast, and I'm honored, and I appreciate it.
And I will say one other thing that I love about Bill is he's a great, actually a phenomenal musician, plays guitar, plays pedal steel and other things. And he's a professional level musician who's played in all kinds of concerts and things. And he's a joy to hear. So if you ever get a chance to hear him play and perform, I certainly suggest you do that. So Bill, as we start off this discussion of trying civil jury trials, I thought we'd start off with the question of, what's one of your satisfying or most satisfying trial victories? I know you've had a lot of them, but what's one that you can share with us?
Uh, Boy, Monty, when you talk about satisfying trial victories, of course, what goes to my mind is the victories as well as the defeats, because there's been ample of those as well. But and I've got several that I'm honored and proud of. I guess one of the most that I'm happiest is a recent verdict that I got out in Santa Monica, which was I represented a catastrophically injured young man who was severely injured in a traffic accident. There was a lot of disputes here and there on the case. The bottom line was I was able to get this family uh, quite a bit of money. And it ended up going to an excess verdict. We just recently concluded the bad faith case. Anyway, the bottom line was it was good, but there's been so many. I mean, I've had the good fortune of and the cases that are memorable that you say, wow, I'm proud of myself. I'm proud of my firm. I'm proud of being a plaintiff's lawyer. Are the ones where you have been able to change a person's life and their family's life. And also, in addition, I'm very happy and I'm proud that plaintiffs lawyers, and I include myself, we change somewhat society for the better. One case I tried against the state where we got it was the shoulders of the freeway were too narrow, and it resulted in a death of a man who was stranded on the freeway with his car. He went to get out of his car. Anyway, the bottom line was we got the freeway shoulders widened to where they should have been. We've had over the years stop signs put up, stop lights put up. Recently, I had a case where the timing of the traffic signals were changed because of our case. So there's been a lot of cases, and it's not always being proud. And I talk for all plaintiffs' lawyers, and that is, it's not always being proud to help one client. We're proud that we're able to help make some safety changes to make it better to where it really won't happen again. And there's been so many examples of those that I, along with others, can comment on.
Yeah, that's a special thing about being on the plaintiff side of the aisle, and everybody does an important work in trying cases for both sides, but you certainly get the opportunity to make a tremendous difference when somebody's been hurt catastrophically and you're able to provide them the care and help they need for the rest of their life if somebody's at fault for that. But I think you're right, making playing things safer, whether it's streets or cars or products or whatever, that happens a lot because of single lawsuits having an impact and then changing things. So yeah, those are great examples, and thank you for all those things that you do. Now, Bill, you've done a wide variety of cases. I mean, you don't just do, catastrophic auto cases, you've done trucking cases, you've done all kinds of things. So you've seen a wide variety. When you're getting ready to go to trial, I mean, there's that prep period. I call it the grind, where you have to just kind of make sure you get all that stuff ready and you've got it in your mind and in your system you're going to use. So how do you prepare for your trials, and what's your approach?
Yeah. Well, the first thing, I think one of the main things to consider, and that I do and the people in my office do, we are preparing for trial, but I want that word preparing for trial is loosely given to a lot of people. We virtually prepare for trial the day the case starts coming in. And
Right.
that we don't take a case. We don't take a case in the office unless we will be willing to try the case. We don't prepare the case to settle. We don't prepare the case to hope. Okay, we prepare the case to trial. And what we do is we keep a list of the good things that our case has, and we all keep on that list what we call the bad stuff. And that's during the course of the case. We always track the bad facts because we're going to have to deal with those bad facts in trial. So let's write them down. Let's documenting. There is a place on the computer called bad stuff, and we put it in there. And we look in the real mirror. We don't just look in the skinny mirror. We look in the real mirror to make sure that we deal during the course of the case with all the bad things that come up, because no case, or I should say every case, has difficult facts,
Right.
situations. Now, as you get closer to trial, as we get closer to trial within 90 days, we start really honing in, and we start putting our plan together of what records we need to get. We do a set of requests for admissions to try and get the other side to admit certain things such as medical billings. And that way we're not having problems with foundation with medical bills. And it covers both rounds. It covers more than one thing. Not only does it do that, if they don't admit it, and we do have to go the full way in calling foundational witnesses and authentication witnesses, then we'll be able to recover, hopefully at the other end, we'll be able to recover the expenses that went
Right.
forward and fees for having to do so. So we get all of the things of the economic damages lined up, including loss of earnings, loss of capacity, get all those things. We also make certain well before 90 days that we have retained quickly the expert witnesses that we're going to need to assist the jury to understand the case. So in a dangerous condition case, where there's an issue of a roadway or a dangerous condition of sorts, we promptly, as soon as we retain the case, we get experts out there to the scene, document it, video the scene, and we get the opinions quickly. Now, we are very picky here in the office, and that's not to say we don't interview a lot of cases. We interview a lot, but we don't take a lot, and we will cut bait. You know, it's if our expert gives us an indication that, hey, we don't see it, well then I was wrong. Maybe am I thinking it was a defective condition or a dangerous condition? It was wrong. But you know, a lot of times we do explore and we hunt and we dig. And so as we do get closer to trial, it's a filtering process. It's like a sifting. It's like the flour sifting through a sieve. As you get closer and closer to trial, you get more and more of the just the true juice of the case. And all the while we're thinking about what's the theme of the case going to be,
Yeah.
and where are we going to hone in on, and what's the timeline. We try to put a timeline together of chronology to where we can explain the case,
Right.
always working toward giving that opening statement. And one thing that we do, Monty, is here you know, in advertising, what they do is they storyboard, or back in the old days, they would storyboard ads. We actually storyboard cases. As the case goes along, we prepare PowerPoints and we do slides. And as the evidence goes in, we put the evidence into a PowerPoint, and that way we can shift the slides around where it's going to go so as to tell the story. That kind of helps us get ready for trial. And then, of course, within the last 90 days, it's what every plaintiff's lawyer does is we crush it and we pound it. We make certain we're timely on all the subpoenas, get our investigators doing their thing and preparing the statements, opening statements and mini openings and the things of the like.
Well, you covered a lot, and all that is great. I mean, I think the way you do it, and that's the way I've always done it, is you got to take a case and prepare for trial from the beginning. And if it's not worth taking to trial, it's not worth taking. But a lot of lawyers who don't try cases kind of, I think, make the mistake of, I'm going to take this and settle it. But don't you find in your experience, the only way you're going to get the best settlements for your cases for your clients is if they know you're going to be ready to try it and you're going to be there in the courtroom?
I think that's true. I think that's a very well-known situation in tort law, that the lawyers, there's a group of lawyers who are willing to go. There's a group of lawyers who aren't. And so just getting that mindset of trial and the manner in which you take depositions. Sometimes I'll take a deposition and of a PMK, and I refer to the jury in the deposition. Are you telling this jury? And I will do things that reminds not only myself and the defense lawyer, reminds the witness, you're talking to a jury right now. So you can do those things well in advance.
Yeah. Well, one of the things you also mentioned is something I wanted us to talk about, and that is all good trial lawyers are thinking about themes for their case. And I'm sure you've used a lot of different themes because you handle different types of cases. So you've had some different things. But what are some themes that you've felt have been really good for you in your cases when you've been in trial?
Well, I mean, the themes that I have centered around, there are several, but a theme that I've used in the past is I should have.
Hmm.
I should have, and that's on the defense saying I should have. They make a mistake. A defendant makes a mistake. A theme of a case has been I should have. The theme of choices. Some people, some defendants make choices. They make a choice.
Right.
It's the wrong choice. So I choose to use the theme of choices a lot. And obviously in bad faith cases, I've tried some, and the theme was either lowball or fraud. I bring up the word fraud.
Yeah.
I like to bring that up because on closing argument, in a bad faith case one time, I argued if the roles were reversed and my client was uh, was charged with insurance fraud, the state would have no problem penalizing him X number of dollars, 10% of his salary,
Mm.
and of which then I say I want 10% of their surplus or something to the effect. So I mean, themes do come around. They vary. I don't get too pressed with themes, although I try to begin weaving in the facts to making up a theme in the opening statement, and I
Right.
try and get the jurors to understand and themselves create a theme for the case.
Mm.
You know, oftentimes the theme can be, why are we here?
Yeah.
Why are we here? Why wasn't this case settled without saying that?
Yeah. And that's good. I think a lot of people who are experts in trying to persuade people like juries are going to suggest, instead of you telling them what they should think, you're helping them figure out what their answer is. And
Yeah,
that's great.
I
That's
think,
great. Well, now we're talking about trials, and we're going to go through some lots of aspects of it. But as you know, there's a lot of parts of a trial, but I find it fascinating that great trial lawyers have different opinions on this question that I want to ask, which is, in your experience, what you think is the most important part of a jury trial, and
well,
then why?
yeah. So that's a tough question because every trial lawyer is going to tell you what I'm about to say, and that is every aspect of every trial is critical. Um, but obviously, I think we all have portions of the case we think are most pivotal, and mine is the opening statement. I have
Uh,
to think that the opening statement, because this is the front of the case, credibility of the lawyer is being demonstrated, uh, and this includes a mini opening, but uh, the way you handle yourself, the way you outline the facts, your mastery of the facts, your mastery of the case, the way you tell the story of the case in such a way that it's persuasive in and of itself. That is, you're not arguing, but you're just outlining, you're laying the case out in a way where the jurors at the end of your opening statement will fully understand the case, or hopefully they understand the case, and they're going to understand why there's going to be a big ask. And I think that opening statement is so telling. You're reading those jurors. It's one of the first times that you're doing your job where they're seeing you truly work. And I really enjoy the opening statement. And I like to use a lot of graphics. I like to use evidence, obviously, as subject to the other side's approval and the court's approval. But if not, just telling the story in an interesting way without notes and all those kinds of things, just coming out, talking to the jurors, letting them know what the case is all about. I think that's critical, but every part of the case is just essential.
well, every part of a case is certainly important, but I think you're right. Everybody's got their own views about what may be most, pivotal.
Yeah.
Um, Now, you said something that I think is, everything you're saying is significant, but you're talking about you're doing your job for the first time. They kind of see snippets of it when you're doing your voir dire and giving a mini opening, but now you're there and telling your case, and you're also building up, hopefully, credibility. And how important is credibility in the courtroom?
So credibility is everything. I mean, everyone will tell you this, and I think you'll get this common answer, but a jury is not going to want to help someone who A, they don't like, and B, they don't believe. They're not going to help anybody. That's including the plaintiff, but because you're the voice of the plaintiff, or I am the voice of the plaintiff, they have to at least enjoy me to the extent of not dislike me. And that comes out really at the very beginning on the mini opening. And the mini opening is the first time you really open your mouth, because when the jurors walk into the courtroom, frankly, they don't like me because I want money. They don't like my client because they want money. They
Right.
don't defense lawyer because they don't want to give any money, and they don't like the defendant because they don't want to give me money either. So the only one that they trust is the people with lanyards around their necks,
Yeah.
clerks, and if you have a robe on. I mean, then those are the ones that they're trusting, and they don't want to be there. So we have to give them a reason to want to be there in the first place, and part of giving them the reason to want to be there is to let them know you're truly serving a good, just purpose, and your credibility and your integrity uh, as a lawyer and as a person is primary in their mind right now, because they are very suspect of everyone. So I think credibility is just a huge thrust, and your manner and your body positioning, how close you get to them, all those things have a big bearing on gaining credibility and making certain that they trust you.
Yeah, and I agree completely. And credibility of the lawyer is key, but also your client has to have credibility. And when later they hear your expert witnesses, they have to have credibility. So the jury's kind of applying that standard to everybody, aren't they?
Yeah, they are. And that's why I'll tell you, I mentioned earlier that we start preparing for trial when we get the case. I rarely retain experts that I don't have a chance to personally meet in person. Nowadays, of course, we're using Zoom a lot, but I want to make certain that every expert that I hire is not talking down to me or talking down to will talk down to people. They don't talk over people's heads, including mine. And I was a PE major in college, so it doesn't, I'm not very academic in terms of the words that I use. I don't like $5 words. I like to use what I call sixth grade English. And I like when experts use sixth grade English with me. And yet, because of their knowledge of the field, their use of sixth grade English is really, really compelling. That's a great expert.
That's
As
a great expert.
Yeah, and as far as our clients go, we have a courtroom here in the office, and in fact, we're getting ready to put a client in upstairs in the courtroom later on today, who's getting ready to testify. That's only in the deposition, but I want to put them in the uncomfortable position, and I want to let them see how it is. We get them ready, and we will videotape them, and we'll let them see the videotape of themselves. And we try to work with them, not to get them phonied up. We don't want to have them memorize anything, because people don't memorize. It's just things like making certain that they speak slowly, that they walk slowly. Um, I'm always cautious to make certain my clients in trial only, well, back now they have water bottles. Back in the old days, they had cups.
Yeah.
I would make certain that my client's cup was less than half full so they don't spill, those kinds of things.
Yeah.
So, there's a lot of things that come up, but I think that client credibility, witness credibility, and your own nature of how you handle direct examination and cross examination will gain the credibility I think that lawyers need and will get if they do it. I think in a polite manner.
Boy, I think that's absolutely true. Now, I like your use of the terms sixth grade language. It always seems to me ironic that when we go to law school, we learn this foreign language of the law. And if you want to become a real trial lawyer, you got to learn how to speak like a real person again. Just talk normally and simply.
Yeah,
And
I'm serious. I was a PE major in college, and so when I went to law school, I had to learn a new language, but unlearning that language was not difficult for me. Sixth grade English I'm a big fan of that phrase.
No, that's great. And if you think about it, how are you going to persuade somebody if you use a language that they don't understand?
Yeah.
I mean, you just can't do that. It's not going to make any sense. Now, one of the things that is interesting these days is we've gone through this, 100-year kind of historic thing with the pandemic and COVID that shut everything down for a couple of years. And I know from our discussion before we started the interview today, we've talked about you've been trying cases since we've come out of COVID. And just for people to get your perspective, what is your view from being in the courtroom and trying cases since we've been out of COVID? Are juries acting differently? And if so, how? And why do you think they might be if they are?
I'm not so sure that the jurors are acting differently, other than I think everybody generally is much more cautious on their spatial aptitude toward things. I
Hmm.
think, uh, um, I know I started trying a case during COVID, and we started live. We then went to a jury trial remote, and it went back and forth a little bit, live and remote. It was awkward. It was unguided. It was frustrating in many ways because I learned a lot about bandwidth, and we had to buy computers for the jurors. But they were attentive. I think that people since COVID are probably a little bit more aware of uh, how frail life can be. I mean, we all get sick, and it's funny. It started. We're getting COVID. If you got COVID, it was like, you got a scarlet letter.
Right.
But now, of course, everyone seems to have had it, and it's not that bad. I have a tendency to believe since COVID that I think verdicts have been a little bit broader. I think um, I don't know. It's hard to say. I can't really generalize, but I think people are the same. But I think that it just seems as though verdicts have been a little bit more enhanced since COVID, and I think that people are just more aware of health generally and health of others. And I think just that focus can be that idea is something that we can use in our trying to be persuasive. Just that, hey, health, we take health for granted, and now not so many people are taking health for granted.
Boy, that's sure true. So in getting ready for a trial, do you use focus groups on a regular basis, or have you done mock trials? And how do you use them, and how do they help you?
Excuse me, man, I'm sorry. Um, I've used both. I've done mock trials, and I've used focus groups. I don't use them on a regular basis. I probably will use them more where we just prepared a case that the front part of a large case concluded. So we were right just before the focus group was going to happen. Focus groups, they do help. They broaden scope. They broaden your mind. It's funny how they bring things up that people, a lot of really good lawyers, a lot of really good uh, staff, and uh, focus group people themselves. People bring things up that we didn't consider. They hone in on facts. They let us know about facts that are more important than we ever thought that they were. And yet, I think when you look at a case like an MRI instead of like a two-dimensional X-ray, and that is you really look at the case, you look at every aspect of the case, and you have a good fundamental understanding of what the case is about. Although, no matter how much of an understanding that we have, getting an unbiased, no dog in the fight perspective is always good. So I think it's very good. I'm not such a fan of these online services for the focus groups as much as I am having people in person. We did combination focus group and a mock trial on a products case that I had, and we were having difficulty with boy, it was a situation where a lighter didn't have a safety device on the lighter, and mom and dad left the lighter where the 4-year-old could get the lighter on top of a piece of furniture. Anyway, the young man got the lighter, burnt the house down, and his brother was severely burned. We went after the lighter manufacturer, and we just couldn't come to agreements on liability. And every time I argued to a mock jury that mom and dad were not negligent at all, we got bad results. Every time I conceded liability, being 50-50, we got great results. So that helped us get an understanding from
Ah,
those kinds of things, and it worked out. It worked out. What it ended up doing is it helped us really evaluate the case for settlement.
yeah, I mean, talented trial lawyers who try all these cases, you just don't see some things the way the juries see them, and it can be very helpful. So that's a great example of how they helped you out. Now,
Yep.
when you're giving a mini opening um, at the beginning, and that's kind of the first time the jury's hearing from you,
Yeah.
you're trying to make it short. And are you talking about what's your strategy in the mini opening? What are you trying to do?
Well, the mini opening is phenomenal, and that is number one. I always do it, and the code now permits you to do it. Period.
Right.
So it's the first time that a jury sees you work. It's the virtual first time they see you work. You stand up and you begin. I never go over 3 or 4 minutes. And one of the reasons I like mini openings is because mini openings is going to explain to the jurors why you're asking the questions on voir dire you're going to be asking.
Hmm.
It's not just getting the message across. So many lawyers think that the mini opening is truly an opening statement and you're there to convince. You're really not. You're, in my mind, you're there to introduce the case to the jurors, and you're there to. I like to get some of my bad facts out during my mini opening
Yeah.
because it'll explain some of my questions on voir dire. But I like to introduce the case. I like to display my personality. I like to display my client's case in a matter of less than a minute explaining the case. Uh, I think it's a big mistake to overstate your case. I do not give away the great facts of the case in the mini opening. So many lawyers jump on. They'll tell the juror the light was red 16 times in their mini opening statement. Yeah,
Hmm.
you don't need to do those things in my mind. It's just introducing the case, letting them know basically what your theory is, and then letting them know some of the bad facts. And then setting up your voir dire is a big part of the mini opening.
Now, as the plaintiff's attorney, and you're only going to handle a case if it's got significant or catastrophic damages. So do you first talk about damages in your mini openings, or do you wait for the voir dire, or do you wait for the opening statement? What do you do?
I touch on the damages probably at the end of my mini opening statement because so many of the cases I try, um, the damages are not going to be tremendously disputed other than life care plans, maybe survivability. It could be the expectation of life. I mean, I don't dwell on damages on my mini opening statement. I do explain to them I'm going to comment on damages in a little while in a formal opening statement, and I do go into damages heavily in my opening statement. But on the mini, I touch on it, but I don't dwell on it because I don't want them to think this is all about just money, money, money. I want them to understand this is about. It's going to be a trial that you're going to hear about a case. It's a story. I try to tell a little bit of the story, uh, let them know where the disputes are, let them know what they say, let them know what I say. I don't start justifying anything, and then I explain to them about the extent of damages, the reason why we're here, is the damages. And then I try to bring out the areas on voir dire that I'm going to be bringing out.
Okay. And in the dealing with damages, I mean, the economic damages are easier in some way because that's kind of quantifiable, even though there may be some disputes about how the numbers add up. But, you know, the non-economic damages and trying to get people to understand how should they compensate somebody for loss of enjoyment of life or changes or pain or things like that. When do you start dealing with those kinds of issues and damages? Is that in your opening statement? Is that some other point?
Yeah, I deal with damages in my opening statement, and what I'll do is there may be a dispute as to the nature and extent of a brain injury, for example, or of any injury, and I will explain on opening without arguing as best I can that pain is not is not you can't see pain. You don't see pain,
Right.
and you won't see pain of my client, or you won't see certain things. And I talk about that on the during the course of the trial. The non-economic damage support does not come from my client. The non-economic evidence comes from others around my client. I very rarely have my client testify as to pain. I would prefer their loved ones take care of that, their children, teachers, coaches, clergy, anyone, co-workers around them can describe, and it doesn't take a wealth of testimony. It just takes quality testimony of quality people. Very picky on the witnesses I choose to testify as to the damage of my client's suffering or has suffered.
Yeah. And so you're asking these friends, coaches, others to just share what they've observed about how your client's been changed and how things are different after this accident or whatever happened, right?
Yeah, the before and after is and friends are a great source of this. Um, and they people know people, the jurors, every juror has friends, and they know they've seen differences in people, and
Yeah.
know and they're very compelled in my mind of what friends say about other friends, especially when the quality of the friendship is what it is. Doesn't always mean a number of years, but it's the quality of friendship, and of course the quality of the person testifying and their credibility. And we don't have a choice. I mean, it's not like we're doing Law and Order where we can pick the roles of these actors and they're great. Well, some of our friends, they can be sleeved with tattoos. They can have tattoos on their necks and their faces. Some of the friends are across the board, as you well know from trying cases. But one thing that I think jurors are very well swayed by more today than ever, and that's just the quality of the person. The jurors of today are not swayed anymore by long hair. They're not swayed by tattoos. They're not swayed by these extrinsic things that maybe my folks and their folks would have been, really altered by. So I think the quality of that friendship and their sincerity of their testimony really plays a great deal. And we use that in closing argument.
Yeah, I'm sure you do.
Yeah.
So in terms of when you're actually asking the questions in voir dire and you're picking your jury, do you work with jury consultants on a regular basis, on a occasional basis? And do you defer to them, or do you sometimes make the decision on your own, even if somebody tells you different advice?
I've worked with them before. I do not work with them often. I'm working with one right now. Whether or not I defer to their thoughts or not, I try not to get it to that position. I try to formulate more of a team structure. Um, they do a lot of behind the scenes work on during the days of selecting a jury, getting information. I don't know, picking a jury. you know, it's so personal. It's all about relationship and your feel and your vibe.
Mm-hmm.
Um, it is something that I usually go on my own gut reactions of things. I'm always interested in what my client has to say, but you know, they're leaving this thing in my lap, and I pretty much call it crazy confidence. I don't mean to have crazy confidence, but I feel like I I I feel like I have it, and I listen to people. I'm all ears. I try not to be a dominate, but when it comes down to it, it'll be my call.
And I mean, some lawyers are looking for certain people that they don't want to have on the jury by profession or other stuff like that. How do you make those judgments when you're trying to decide, hey, is this somebody that I feel comfortable with on my jury?
Well, I stay out of Torrance if I can because they've got nothing but engineers there, and uh, I don't mean to knock engineers, by the way, but I'm just saying that there's certain professions, there's certain people, whether no matter what profession they're in, but there's certain people that have bright lines, and things are either black or white, and that's that, and they tend to be uh, people who snap in decisions, and not only do they snap in decisions, the decision they snap into is the right decision, period. Um, I don't mean to say we always want psychologists and things like that, but we're looking for people that are at least open-minded. I don't I've been wrong before. I'll be wrong in the future, but man, I just want to have a clean shot, and I want the other side to have a clean shot, because what's good for the goose is good for the gander. But I just want to avoid people that I get a vibe of just abruptness and bright line. I'm right, you're wrong, and those kinds of things come out because I talk a lot about lawyers and people who have these billboards up, and your name's on the side of a bus. Do you equate me with those people? And
Yeah.
you know, I fight for you on TV, all this nonsense. So and we get a lot of interaction, and that ties also in with some credibility things.
Yeah. Well, in your trial, you've always got some bad facts, as you mentioned before, and you've talked a little bit about dealing with those in opening statement, but are there other ways that you deal with the bad facts in your case throughout the trial? And also, what's your strategy when the defendant's sympathetic, and how do you try to deal with that? Because the jury may feel sympathy for the defense.
You know, a sympathetic defendant, man, that happens, and it's happened to me a couple times where the defendant really just appears better than the plaintiff. I mean, let's get real here. Sometimes, well, I do. I say, who looks better, the plaintiff or the defendant? Sometimes, and I mean, when I say look, I'm not just talking about appearance. I'm talking about the whole global aspect of their presence. And sometimes the defendant just does. And uh, that could tie into the theme of the case. The theme of the case meaning uh, even nice people run red lights. Okay, that could be the theme of the case, or even nice people do things that have to be compensated for. And I would spend a lot of time on voir dire in that situation. Do you think a person who's injured by someone who's a nice guy or gal should get less because the defendant's a nice person? And tell me your thoughts on those things. Do you think that you know, in the old days, lawyers would wear wigs and you wear the same thing because everything was going to be the same, because they wanted to nullify certain different prejudices on, and so I talk about that with well appearing defendants or defendant corporations where they're doing things that are good for people.
Hmm.
I think that with regard to bad facts, Monty, I weave them and I face them. And what I try, the word I try and use is embrace. I try as best I can to embrace a bad fact. I was getting ready to try a case a couple of years ago, and 3 weeks before the trial, my client, it was a wrongful death of his wife. And 3 weeks before the trial, I asked the client, as I always do, I said, is there anything else I should know about you or your case that I don't know that would make a difference to a jury? Just be open and honest. Well, for the first time, he tells me he's been having an affair.
Mm.
And I not only do I know the defense lawyer, I know the defense lawyer would give me a decent offer. It's not a great case, but it was a case. And so I had, and he's a good lawyer, and I just knew he knew they did their homework.
Mm.
So I had to on my on voir dire, the theme of that case completely shifted, and the theme of that case became mistakes. And in this case, the city made a mistake by having something adjacent to the road, and my client made a mistake because I'm letting you know right now, day one, moment one, he had an affair on his wife. And I'm letting you know that right now. And it was my openness and my honesty that I think ultimately allowed me to win that case. Now, it certainly had a compromising effect on the value of the case.
Right.
Where I think it should have been 10 million, it was only 2.5 million. But the bottom line is that mistake that my client made, it was a terrible fact. And I just embraced it. And I mean, there's some you can work with, but that was just too much.
Yeah. That's that's tough.
Or
I
too
ended up having I had a bad faith case where my plaintiff, who was a doctor, had been sued by his client because he had an affair with her. And of course, the carrier said it's intentional misconduct, and he ended up settling the case before it went to trial. But, I had to just admit what he did was wrong. But what the carrier did was wrong too, because he bought that insurance and he needed protection and they just dropped him.
Yeah.
So, you know, you got to deal with those bad facts. So when you're in the courtroom, one of the things that happens, all trial lawyers are cross-examining witnesses and doing that kind of stuff. And there's, in my view, kind of the traditional closed cross, you're controlling the witness, only yes or no answers, that kind of stuff. And then there's kind of what I think of as a jury Spence open cross, where you're just kind of telling your story and you don't care as much what their answer is. Do you use one or both of those? How do you cross people?
Well, I think as far as cross-examination goes, boy, if there's an area of preparation that I spend a lot of time preparing for cross. And I pretty much plan my cross and cross my plan.
Yeah.
And I think that I rarely go shooting at the hip um, and you refer to Jerry Spence. I mean, what a phenomenal lawyer. He got phenomenal results, but he tries to make you think that he was just shooting at the hip. But many times he had a very, very good idea on exactly where that witness was going to go. But there are those times where you don't have uh, the answer. And it could be, and I've had situations where I just know the jurors are dying to know what the answer is. And so what I'll try and do is I'll try and circle the wagons and lead them into something to where I can provide them an answer and get a glimmer of where the answer is going to go.
Hmm.
Have I ever asked the question who I didn't know the answer? Yeah, I've asked that question, but it's pretty rare. I like to have an idea because one answer can blow the whole case. And
Right.
never do I do that, by the way. Never do I do that with an expert. I don't do
Right.
it.
Right. Right. Well, I agree with you. I think you're almost it's going to be a rare occasion where you'll ask a question where you don't know the answer, but every once in a while,
Yeah.
and in my trials, when I've done it, it's where, like you prepare and prepare and prepare for cross, and you know this one area, but you don't know the answer. But if you know that case really well and you're prepared, you might be able to figure out there's no good answer for them. And if
Yeah,
there's no good answer, then I'm willing to ask the question then. But if there's an answer they can kill me with, I don't want to ask that.
yeah, it's a little tough. But hope you don't get yourself in that spot. And that's where the power of a deposition really comes in, that you've hopefully asked that question. So you do.
Yeah. In your impeachment of witnesses during the trial, do you find that using video clips of the testimony is helpful in impeaching them in front of the jury or in the jury's minds?
Um, I've done that. I think what's for me, the more powerful way or a powerful way of impeaching is I will oftentimes remind a witness or have to read what they testified to in a deposition.
Right.
And then what I'll do is, as I cross-examine them, I will hold that deposition physically in my hand. And they know the color of that deposition. They've studied that. They know exactly what that deposition is. So when I suggest an answer to them in a leading, cordial fashion, being civil, I may even point the deposition at them. I mean, not disrespectfully, but I'll have it in my hand. And then if I need to, I will cite, and I have page lines pretty rigorous for cross. And then I will just let the judge know we're going to read the deposition. I will read my exact question, and then I'll ask to approach, and I'll provide the deposition for the witness, and I'll ask the witness to read his answer, and I'll have the witness read the answer.
Mm.
It only needs to happen once or twice before they pretty much will tell you the answer is yes to whatever you want to say. I mean, not every, it works out pretty, but I've used video clips. But I think that number one, if you're going to use a video clip, you better have that video clip. I mean, like right now, ready to go,
Oh,
because
you got to have it ready. Yeah.
no white noise, no silence, no fumbling, no, oh, I can't find this. And that could be a problem because timing is everything on cross.
Yeah. Well, I think you got to have it ready right away, but you also have to have a clean clip. You got to just get a clean question, clean answer, and none of this BS at the end where they're adding other stuff.
Right. Because it's if you want to really drain a great clip, just have the jury hear something that's not even impeaching, and it's muddied up with all this
Yeah.
stuff. So
Well, you lose credibility, don't you?
yeah, that's it.
So we've been trying this case, and you're putting on your evidence, and you've made a great opening statement, and now we're getting ready for the close and the final arguments. Um, when you're in your final argument in front of the jury, what do you do to try to help them figure out how they should come up with a value for non-economic damages in which your client either has suffered or will suffer throughout the rest of their life?
Yeah, well, what I do is number one, I use the verdict form, which a lot of us use, and I like to use the jury instruction 3905A, which outlines for the jury the elements and the component parts of what they must award if they find liability. And I put that jury instruction up on a PowerPoint, but I select each area that is identified in the jury instruction. Okay. And I put each area I segregate and put a slide up and I talk about it. So if you're talking about disfigurement, I talk about just what disfigurement is and the impact that it's had on this person's life, and grief, what it is, the emotional distress. Let's talk about those two words for a moment. I mean, we've all had it, but let's think about that and put it in the eyes of this person. And I put each one of those things down. Now, I've done it a bunch of different ways where I've actually created a slide where I identify each of those areas of the jury instruction, and then I put a life expectancy out So if the life expectancy is of a person's 36 years or 31 years or 20, whatever it is, I talk about, well, what is it worth to have pain? What is it worth to have the kind of pain that you can't see it, but you know it's real? The doctors have said it's real. It's debilitating. It hurts, and all the evidence that you heard is that, and I put it in a how much? Well, I mean, to get Novocaine, the dentist charges you X number of dollars for to avoid pain in Novocaine. So in some way, what I'll do is I'll calculate an hourly basis of for the rest of this person's life for each of those slots
Mm.
of grief, of pain, of disfigurement. And when you put it down to an hourly basis, um, is it you think it's worth $10 an hour to be without pain? And that's a per diem way to do it. And when you calculate each of those segments up with the total hours, with the total dollars, it usually can work out to be a substantial number. Another technique is using what people equate with money. Okay, Otani just signed for 70, what was he? I think it was $700 million.
700 million, yeah, with the
10 years.
Dodgers.
Yeah, okay. Well, now that's obviously a 1 in a million guy, and 1 in 20 million guy.
Right.
But when you think about a Monet or a painting that's worth 40 million, and the reason is because it's one of a kind. It's a one of a kind painting painted by a one of a kind person. And just like the plaintiff's wife was, she was a one of a kind. And though you can equate those things and what people value as the value of money, um, I've argued that a curator of a museum was asked a fireman was asked by a curator of a museum to go in to get a painting out of a room that was worth, it was a Picasso that was worth, $65 million. Please go and get that painting. And the fireman goes in to get it. And as he's reaching to turn right to go to the room where the painting is, he hears a little girl screaming. So what does the fireman do? Does he get the painting or does he help the little girl? Well, obviously he helps the little girl. That's the value of a life. Those kinds of analogies can be impactful on jurors. A lot of us have used the jet airliner, the ejection seat, to save $100 million aircraft. They say just pull the ejector seat, save yourself. Don't worry about the plane.
Yep.
You don't see the government saying, "Hey, ride that plane down." So those are analogies that we've used in death cases and in pain. Um, I just think your credibility as a credible lawyer who has demonstrated throughout the trial and throughout the case your devotion to your client and your belief in their case, because it rubs off.
Right.
You don't tell a client, "Hey, meet me up in Department 6. I'll be up there and I'll meet you the first day of trial." I mean, we walk together. I mean, we are together. We are a team, and the jurors, I make them see globally, we are a team together in this thick and thin.
Right.
Win or lose.
Well, that's great, Bill. We've been having a wonderful discussion. Our time is getting close to the end. It goes by way too quickly, but you've been sharing such wonderful information. At this point, for us to kind of wrap things up, my hope is that this is going to be helpful, and I believe it is from feedback I've received already, but this podcast series will help younger lawyers who haven't tried that many cases learn from masters like you, and they'll become better trial lawyers in the future. So what kind of advice would you give to a younger lawyer who's not very experienced, maybe hasn't tried a case or only tried one or two? What advice would you give to them?
Well, first of all, thank you for saying those kind words and putting me in that class. Um, I think one of the things I'm going to say has been said millions of times and over and will continue to be, and that is you have to prepare your case for trial. As I earlier mentioned at the beginning of this podcast, you have to prepare from day one, and you have to master your case. You have to truly master the case and not fool yourself thinking that you know enough. You can't wait 30 days before to start reading depots. You have to know the case. You have to have an attitude that you are gonna you're gonna be your client's voice and be proud of being that voice. And you have to have an element of confidence. And it's tough because uh, we're not born with that skill. You know, I teach trial practice, and I tell the students, you're not born with this skill. I didn't have it. It's not innate. It's a learned skill. Some people sure are better than others, but what you have to do is let the goodness be your guide, and that is you're representing someone who deserves you and deserves what you have to offer and deserves their story to be told. And that element of confidence has to be there in your presentation. It takes practice, it takes preparation, and it takes a lot of gumption, and it takes willingness to lose. You show me a lawyer who just is afraid of losing, and I'll show you a lawyer who's going to lose. Now, we've all lost. Anyone who says they haven't lost hasn't tried a tough case, period.
Right.
And so I would just suggest to the young lawyers and even some not so young, number one, we're all students of the law. We're all striving to be better every day, every trial. I don't care how many trials we've tried. And but what I try to do is remind myself to always be on the edge of fearing not being prepared. You'll beat me, but I seriously doubt you'll out prepare me. But and I think that attitude and being devoted to your case and sincere and being honest with your client all the way through will help you try the case. And then be honest with the jurors. Just let them know. If you have to let them know. I had a friend of mine who told, for the first 10 trials, he told the jurors this was his first trial. He was nervous. He kept using that line. And I mean, I don't know what it got him. I mean, I remember the first trial I tried. I remember it vividly. And I was scared, all the things that all young lawyers are. But the bottom line is I did what I had to do. And you know, I think young lawyers who want to be trial lawyers, they will pass that line of the ultimate fear. They'll get through it. And if I could ever help anybody, I'm here like you are, Monty, to help.
Well, Bill, thank you so much. That's great advice. And thanks so much for being a guest today. You have been a wonderful guest. And congratulations on your work ahead leading ABOTA into the future. And I know you're going to be a great steward of a great organization. So thanks so much. And thanks for being a guest today.
Thank you, Monty. I appreciate your kind words, and I thank you for serving our profession.
Thank you.